Sadly, government is not the only institution that discriminates. Private businesses and private individuals do so as well. The Constitution gives Congress the power to pass laws to enforce the Equal Protection Clause.
And Congress attempted to do just that when they passed the Civil Rights Act of 1875. The Act of 1875 made private racial discrimination illegal in transportation, in accommodations, and in other areas of life. But in 1888, the Supreme Court struck down this Civil Rights Act, saying that Congress didn't have the authority to pass it. This case instituted what came to be known as the State Action Doctrine. Quite simply, the State Action Doctrine says that the 14th Amendment only relates to public or governmental discrimination and doesn't relate to private discrimination. As a result, the 14th Amendment does not give Congress any new powers to pass legislation to ban or regulate private racial discrimination. And this is the way things stood for almost 100 years until 1964, when Congress passed another major civil rights bill. The Civil Rights Act of 1964 prohibits not only racial discrimination, but also gender discrimination in many different areas. These include things such as banking, housing, education, and employment. Once again, opponents claim that this law was unconstitutional, and the issue was decided by the Supreme Court in Heart of Atlanta Motel v. U.S. The suit was brought by the white owners of a motel who did not want to serve non-white clients. They claimed that because of the State Action Doctrine, Congress had no power to combat private racial discrimination. This time, however, the Supreme Court upheld the law. However, this case was not based on the Equal Protection Clause. It's not the Equal Protection Clause that gives Congress the power to combat private racial discrimination. Rather, the court said Congress has the power to combat private racial discrimination under the Interstate Commerce Clause, because racial discrimination does have a negative impact on interstate commerce. The Civil Rights Act of 1964 made both racial and gender discrimination illegal. Since then, Congress has passed other laws protecting other groups against discrimination. These include the Americans with Disabilities Act, the Age Discrimination in Employment Act, which protects workers over the age of 40, and the Pregnancy Discrimination Act, which makes it illegal to discriminate on the basis of pregnancy. In addition to federal laws that prohibit various kinds of discrimination, states can also pass anti-discrimination laws that go even farther. For example, there's no specific federal law that prohibits discrimination based on sexual orientation, but many states, including California, have such a law. And finally, summarize the key distinctions between public and private discrimination. Public or governmental discrimination is prohibited directly by the 14th Amendment and requires no additional legislation. Private discrimination is only banned by state and federal law, and those bans can be reversed at any time. For example, if Congress wanted to reverse the Americans with Disabilities Act tomorrow, they could.